Picture this. You're sitting at home on a quiet evening, maybe just having dinner with your family, when suddenly there's a sharp knock at the door. You open it, and it's the police. They want to speak with you. I mean, for almost anyone, the immediate instinctive thought is just panic, right? But let's pause right there for a second and ask a really critical question. Can the police legally summon you as a witness just because they think you might know something about a crime?
And let's say you do receive a formal notice at your door. Do you actually have to just drop everything you're doing and appear before an investigating officer? It's an incredibly tense, intimidating situation for any citizen. A lot of people just assume they have absolutely no choice but to immediately comply with whatever the police ask of them, mostly out of fear of getting arrested if they don't. But knowing exactly where you stand with the law, knowing your rights and your actual obligations, is absolutely crucial to protecting yourself from any kind of overreach.
So, welcome to The Explainer. Today, we're breaking down a highly critical piece of legislation that honestly affects every single citizen. We're talking about Section 160 of the Criminal Procedure Code, or CrPC for short. This is the exact legal provision that governs police summons for witnesses during a criminal investigation. It literally dictates exactly what the police can and cannot do when they need your help to solve a crime. And understanding this, it isn't just for lawyers. It's basic, essential civic knowledge.
Now, I know legal codes can seem pretty dense and intimidating, but don't worry, we're going to make this completely accessible. Here's our roadmap for today. We'll start with the investigation process, move on to Section 160 and summoning witnesses, compare a witness versus an accused person, look at legal safeguards, dive into questioning rights, and finally, we'll walk through a practical example. Okay, let's dive right into this with Part 1, the investigation process, and look at exactly why the police might need your statement in the first place. To truly get how police summons work, you first have to understand police duties. Under Sections 154 and 157 of the CrPC, when a serious crime is reported, what the law specifically calls a cognizable offense, the police don't just have the option to look into it if they feel like it. No, they have a mandatory statutory duty to investigate. They are legally obligated by the state to uncover the truth, figure out exactly what happened, and track down the culprit. And to do that effectively, they can't just rely on forensics, right? They absolutely have to gather verbal statements from ordinary citizens who might be connected to the event. Which brings us perfectly to Part 2, Section 160, Summoning Witnesses, and the actual power to require your attendance.
So, Section 160 of the CrPC empowers a police officer who is making an investigation to require, by a written order, the attendance of any person who appears to be acquainted with the facts and circumstances of the case. Now, the crucial elements here are twofold. First, it can't just be a casual phone call, a quick text message, or an officer yelling from a passing patrol car. The law strictly requires a formal written order. Second, they can't just summon anyone randomly for some massive fishing expedition. You have to be someone they reasonably believe actually possesses factual information about that specific case.
Moving right along to Part 3, Witness versus Accused, and knowing your exact role in the investigation.
Now, getting a formal notice from the police can make anyone instantly feel like a criminal suspect. But what's really interesting here is the clear legal distinction drawn between two very different roles. The witness is simply a person acquainted with the circumstances. You're a bystander providing helpful information to the state to help piece together the truth. The accused, on the other hand, is a suspect actually facing potential criminal charges. The justice system treats these two very differently. Because of the historical risk of forced confessions, statements made by an accused person to the police generally cannot be used as evidence against them at trial. But as a witness, you're not under that shadow. Your primary role is simply to assist the justice system with what you saw or heard.
All right, let's look at Part 4, Legal Safeguards and the crucial exceptions to Section 160.
This is arguably the most vital part of our explainer because the police's power to summon citizens is absolutely not absolute. Notice the ironclad protections the law provides for specific vulnerable groups here. If you are a woman or a male under 15 years of age, you absolutely cannot be summoned to the police station under Section 160. No exceptions. This rule exists for a very specific reason. It's designed to protect these demographics from potential harassment, intimidation, or undue pressure in a station environment. Instead, the investigating officer must come to your place of residence to examine you. While legal experts note this protection is sometimes unfortunately violated in practice by unaware officers, it remains a mandatory, non-negotiable legal right that you need to know and assert.
And here is a massive practical takeaway to remember. If a female witness is ever compelled to appear at a police station to give her statement, it's not just a minor clerical mistake, it is a serious procedural irregularity that courts actively frown upon. The law unequivocally demands that the police accommodate her at her own residence, surrounded by her own secure environment, ensuring her dignity and safety are entirely preserved.
So what actually happens when you are finally sitting down with the investigating officer? That brings us to Part 5, Questioning Rights, and Section 161 and your statement. Once the questioning actually begins, Section 161 of the CrPC takes over. This specific section governs the official recording of your witness statement by the police. In legal circles in courtrooms, you'll hear this commonly referred to as your 161 statement. It's incredibly important because it forms the very foundation of what the police will present as your official, documented version of events. Think of it as the building block of their entire case file.
So the crucial point here is understanding that delicate balance between your obligations and your personal protections. Yes, you are legally bound to answer questions truly. You can't just lie to hinder an ongoing investigation. However, you are absolutely not obliged to answer any questions that would expose you to a criminal charge or a penalty. You can flat out refuse to answer those specific questions. Furthermore, it's really important to know that your 161 statement to the police isn't substantive evidence in court to prove guilt. It's simply the initial written record of your account, meant to guide the investigation, not definitively convict someone.
And you know that right to stay silent if an answer would incriminate you? That isn't just a minor procedural loophole tucked away in the criminal code. It directly mirrors Article 13B of the Constitution of Pakistan. It is a deeply rooted fundamental civil liberty. The state simply cannot force a citizen to testify against themselves. This provides a massive, constitutionally backed shield against overzealous interrogations and ensures the pursuit of justice doesn't trample your rights. Let's make all of this entirely concrete with Part 6, a practical witness example, and walk through a hypothetical case together. Let's see how this builds from the ground up. Step 1, a theft occurs in your neighborhood at a local shop, creating a cognizable offense. Step 2, the police, fulfilling their mandatory duty to investigate, identify you as a nearby resident who might have seen the thief running away. Step 3, because they need your account, you receive a formal written notice under Section 160 requiring your attendance. And finally, Step 4, you sit down with the officer, you answer their questions truthfully without incriminating yourself, and your statement is officially recorded under Section 161. But here is the real-world consequence of that whole process that you need to be acutely aware of. While your 161 statement isn't absolute proof of guilt, it effectively locks in your version of events right from the very beginning. If the case eventually goes to trial, which, let's be honest, could be months or even years later, and you give evidence in court that materially contradicts what you told the police in that initial statement, the defense counsel can and absolutely will use that 161 statement against you. They'll use it to attack your credibility on the stand, trying to show the judge that your story is changed. We've covered a lot of crucial legal ground today. Let's wrap things up with Part 7, Key Takeaways, and go over what you absolutely must remember.
This whole process brilliantly illustrates the delicate balance the law strikes between giving police the power they need and protecting the rights citizens deserve. Remember, Section 160 strictly requires a written order to summon you, no casual demands. Women and boys under 15 are absolutely protected and must be questioned at their residence, not intimidated at a busy police station. During questioning, you must tell the truth to aid the investigation, but you can never be forced to incriminate yourself. Ultimately, fair, transparent, and highly effective policing relies entirely on the cooperation of protected, informed witnesses like you.
So, I'll leave you with this final provocative thought. Armed with a deep understanding of Section 160 and Section 161, will you know exactly how to protect your rights and fulfill your civic duties the next time a police notice arrives at your door?
Thank you so much for joining me for this explainer. This has been Pakistan Legal Insight, promoting legal awareness to simple explanations of the law. Keep learning, stay informed about your rights, and stay empowered.